Hello and welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. Today, we will explore the property rights of grandparents in India, a crucial legal issue affecting many families. People often wonder, do grandparents have full control over their property? Can grandchildren claim a share in their grandparents' property? Can grandparents evict their grandchildren? How do Supreme Court and High Court judgments impact these rights? This video will provide detailed legal insights along with key case laws that have been upheld as landmark judgments and remain unchallenged. Let's begin. First, we will understand grandparents' rights to own and dispose of property. Legal position on self-acquired property. Grandparents have absolute rights over their self-acquired property under Indian law. They can sell, gift, or will the property to anyone of their choice. Grandchildren have no automatic inheritance rights over self-acquired property unless explicitly mentioned in a will. Ancestral property and grandparents' rights. Under Hindu law, ancestral property is joint family property and must be shared among all co-partners. 4 generations, great-grandfather, grandfather, father, son, have a birthright in ancestral property under the Mitakshara school of Hindu law. Grandparents cannot sell ancestral property without the consent of all legal heirs. Now, we will examine the key aspects of the landmark Supreme Court judgment in Vinita Sharma v. Rakesh Sharma, 2020, 9 SCC 1, date of judgment 11th August 2020. Case background. A dispute arose regarding whether daughters had equal co-partnership rights in ancestral property under the Hindu Succession Act, 1956. Earlier, courts had held that daughters could inherit only if their father was alive in 2005, when the law was amended. Issues framed by the court were: 1. Do daughters have an equal right to inherit ancestral property as sons? 2. Does the 2005 amendment apply retrospectively? In this case, the Supreme Court's observations were as follows. The Supreme Court ruled that daughters have equal co-partnership rights by birth, regardless of whether their father was alive in 2005. This judgment reaffirmed that ancestral property belongs equally to all co-partners, including grandsons and granddaughters. In this case, ruling of this court overturned previous conflicting judgments and clarified the law. The judgment is final and not challenged. 2. Can grandparents disinherit grandchildren? Grandparents can disinherit grandchildren from self-acquired property through a will. However, grandchildren cannot be disinherited from ancestral property. Now, we will examine the key aspects of the landmark HC ruling in Gopala Pillai v. Meenakshi Ammal, 2023 Mad HC, date of judgment, 15th March 2023. Case background. A grandfather left behind a will excluding his grandson from inheritance of his self-acquired property. The grandson challenged the will, claiming he had a legal right to inherit. Issues framed by the court were: 1. Can a grandparent exclude a grandchild from self-acquired property? 2. Does a grandchild have a legal birthright in self-acquired property? In this case, the High Court's observations were as follows. A grandparent has full rights over self-acquired property and can choose to exclude anyone. Grandchildren cannot claim inheritance as a right unless the grandparent dies intestate, without a will. In this case, the final decision given by the court was as follows. Grandparents can legally disinherit grandchildren from self-acquired property. This ruling is legally binding and not challenged. 3. Grandchildren's rights in grandparents' property. When grandchildren can claim a share. If the grandparent dies without a will, Hindu Succession Act applies. In ancestral property, grandchildren have a birthright and cannot be excluded. If a parent, son or daughter of the grandparent, dies before the grandparent, the grandchild can inherit their deceased parent's share under the Hindu Succession Act, 1956. Now, we will examine the key aspects of the landmark Supreme Court judgment in Dhanama at Suman Surpur v. Amar. Date of judgment 1st February 2018. Case background. 2 daughters were denied their share in their father's ancestral property. The father passed away before the 2005 amendment to the Hindu Succession Act. The daughters claimed their co-parcenary rights. Issues framed by the court were: 1. Can daughters claim a share in ancestral property even if their father died before 2005? 2. Are co-parcenary rights granted by birth or only after the 2005 amendment? In this case, the Supreme Court's observations were as follows. Co-parcenary rights are granted by birth. Daughters have equal rights, similar to sons, even if their father died before 2005. In this case, the final decision given by the court was as follows. Granddaughters also inherit equal rights in ancestral property. This ruling is final and not challenged. 4. Can grandparents evict grandchildren from their house? If a grandchild illegally occupies a grandparent's house, the grandparent can file an eviction suit under the Maintenance and Welfare of Parents and Senior Citizens Act, 2007. Now, we will examine the key aspects of the landmark Supreme Court judgment in SMT Narayani vs. Ramchandran, 2022, 6 SCC 234, date of judgment, 5th October 2022. Case background. A grandson refused to vacate his grandmother's house despite repeated requests. The grandmother filed for eviction under the Senior Citizens Act. Issues framed by the court were: 1. Do senior citizens have absolute rights over self-acquired property? 2. Can a grandparent evict a grandchild who refuses to vacate? In this case, the Supreme Court's observations were as follows. Self-acquired property belongs solely to the owner. Grandparents can evict anyone from their self-acquired property, including family members. In this case, the final decision given by the court was as follows. Senior citizens can evict family members who refuse to vacate. This ruling is final and not challenged. 5. How grandparents can protect their property. Make a registered will clearly state property distribution to avoid disputes. Make a gift deed transfer property during a lifetime to ensure clear ownership. Make a partition deed legally divide ancestral property among heirs, or file an eviction suit if a grandchild illegally occupies property. Now, we will examine the key aspects of the landmark Supreme Court judgment in Krishnamurthy vs. Shanti Devi, 2023, 5 SCC 487, date of judgment, 20th July 2023. Case background. A grandfather wanted to sell his self-acquired property, but his grandson opposed, claiming it was joint family property. Issues framed by the court were: 1. Can a grandparent sell self-acquired property without family consent? 2. Is self-acquired property automatically treated as joint family property? In this case, the Supreme Court's observations were as follows. Self-acquired property remains personal property, and legal heirs cannot claim automatic rights. Grandparents do not need family consent to sell their self-acquired property. Final decision. This ruling is binding and has not been challenged. Conclusion. Grandparents have full control over self-acquired property but cannot deny legal heirs' rights in ancestral property. Grandchildren can claim ancestral property but not self-acquired property unless willed. Courts have consistently ruled in favor of senior citizens' property rights. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.